essentially left-leaning woke progressives that think that democracy will be improved in our state if we allow people who are not citizens to vote in our elections. So when you stop and think about, well, all right, a person who is a non-citizen is certainly a citizen of somewhere else.
Of another country.
Of another country, right. And by not giving up that citizenship and seeking U.S. citizenship, what you're allowing to happen is individuals to come in who haven't professed an allegiance to this nation and who might be unwilling to give up citizenship in another nation that doesn't afford them the same democratic voting rights that we do. But let me just establish this one very important point. There was a historically very close election in our lifetimes in the year 2000. That was the election between George W. Bush and Al Gore, who was the vice president. And that election came down to a very close count of votes in the state of Florida. George Bush was basically elected president on the basis of winning the electoral votes of Florida and winning a statewide election by maybe 800 votes. That determined who the president was. Al Gore challenged that because they had different views about what vote should have counted. There were things called hanging chads at that time and so on and so forth. And the case went up to the Supreme Court. And the Supreme Court, in the case of Bush versus Gore, found that voting in the United States is a fundamental right of citizenship. This means that the rights associated with voting are so strong that no locality or state, including San Francisco or Oakland or Santa Ana or New York City, can affect the fundamental right of voting unless they have a truly compelling state interest. Now, we go over to what happened in San Francisco. 4 years ago, on the third or fourth attempt at a ballot initiative, progressives in San Francisco by 54% passed a law that allowed for non-citizens to vote in school board elections. The underlying idea being to allow non-citizens who are parents of kids in schools to have some sort of a say in who was elected to their school board. Parenthetically, we know that the San Francisco school board is totally dysfunctional,
and they got recalled.
And last year, 3 of them got recalled because they didn't like the idea of naming schools after Thomas Jefferson and Abraham Lincoln. That law was enacted for just 4 years. It had a sunset provision in it. And late last year, that sunset provision gave the Board of Supervisors in San Francisco the option to extend the law. When that happened, and the San Francisco Board of Supervisors voted to extend the law, it gave me the opportunity, within a 60-day window, to challenge the constitutionality of the law. I wasn't able to do it 4 years ago. I wasn't engaged 4 years ago. But because election integrity has become such an important issue since then, we've had our antennas out for these types of issues. How do we improve election integrity? How do we protect that fundamental right to vote that the Supreme Court has said exists? So we went ahead and we filed for what's called a writ of mandate to have a permanent injunction on extending that vote. And our argument was that under a clear provision of the California Constitution, only citizens of the United States 18 years or older may vote. And it's alarming that this ballot initiative even got on the ballot and was allowed to have a vote, and it was a failure of the attorneys who advised the cities.
So it wasn't legal to begin with?
It wasn't legal to begin with, but it was an unconstitutional provision to begin with, but it wasn't challenged that way in court. So it got by, and the initiative passed fairly narrowly. 54% in San Francisco does not reflect what the majority view in the state of California would be. So sure enough, after 3 or 4 months of litigation, Judge Ulmer of the Superior Court of San Francisco, Stanford law grad, a judge appointed by Arnold Schwarzenegger, who sits in San Francisco, made a terrific decision. And he said, you know what, City of San Francisco, you're wrong. The constitutional provision is clear, it's straightforward, and I am enjoining this law. And on the 29th of July, he issued this ruling that restrains from allowing non-citizens to vote in their elections. Now, the city came back 2 weeks later on August 12th, so this is very fresh information, and they tried to get what's referred to as a stay of the implementation of that order so that they could appeal the case to the next level of the Court of Appeals and see if they could overturn the judge's ruling. And the judge came out with, again, an absolutely fantastic ruling. It was a 1.5 page statement, and it said very succinctly, look, this is not a difficult question, and it's not even a close call. Non-citizens may not vote in California elections. So we're buoyed by this decision because we think it will protect election integrity. And if you look at the voting demographics of San Francisco, you'll see this is not something that is that we've promoted because we have this army of Tea Party patriots or Trump supporters that are saying, all right, we don't want any non-citizens to vote. The voting demographic in San Francisco is very diverse and it's very minority tilted. You have a large Asian community, citizen Asians. You have a large Black community, and you have a very large Latino community. All of those groups, particularly the Black demographic, has been historically subject to invidious discrimination and discrimination about their votes. There's a famous case that was decided in 1980 in Alabama about how the city of Mobile, Alabama, intentionally discriminated against Black voters in the way that they set up their city elections to dilute the vote of the Black voters so that the Black voting bloc would not have enough influence to actually elect people to public office. And the Supreme Court found against the city of Mobile and elucidated the notion that voting is so precious it cannot be diluted. You cannot have the state taking power or putting in programs that have the effect of diluting. Well, this San Francisco issue, it was an example of the government pushing a program that had the effect of diluting the vote of the citizen minorities in San Francisco. So if there's virtue, the virtue isn't with the non-citizen voters who don't really pledge an allegiance to the United States and who have other ways that they can participate. There's no rule that says that a non-citizen individual can't attend a school board meeting, can't step up and be able to speak at the public comments. There's no rule against that. It's just the question of voting. So we now have this upheld twice by a Superior Court judge in San Francisco, and we're now turning our sights to the other misguided communities that have also attempted to push this line of non-citizen voting. Already, the city of Santa Ana, just a week and a half ago, took off the ballot an attempt that they were making to have citizens vote in Santa Ana on whether or not non-citizen voting should be approved. And according to the news reports, the city council took that action directly as a result of my lawsuit, Lacey versus San Francisco. Yesterday afternoon, this is fresh news. This hasn't been reported everywhere, but yesterday afternoon, I also myself and other plaintiffs filed suit against the city of Oakland because Oakland has on their ballot for November as well a non-citizen voting law that is similar to the one that was struck down for unconstitutionality in San Francisco. So it's going to be very interesting. The process of taking a law like that, of a proposed ballot initiative off the ballot is a little bit different from the challenge that we had in San Francisco. This particular case gets immediate attention and urgency because the election's coming up in November, and they have to make a decision quickly.
Now,